We are back with another lawsuit breakdown. I am your host, Dave, a 10-year intellectual property attorney dealing with everything from patents to trade secrets to copyrights, as well as trademarks. Now, earlier on in the week, we, kind of gave a summary of an article that came out as relates to the U.S. Olympic Committee suing Logan Paul, as well as his company Prime Hydration, for trademark infringement. So we kind of broke that down. And I told you guys that I will, as I typically do on Sunday, do these trademark or intellectual property lawsuit breakdowns. Unfortunately, I wasn't able to do it live today, so I'm pre-recording this video. And by the time it comes out, I'll probably be on a highway somewhere. I had some travel, so I'll probably be on a highway and kind of taking care of business. But I did want to bring to you this lawsuit. The good thing about these intellectual property lawsuits and actually looking at the lawsuit is that you can see a little bit more of the story of kind of what went down, the communication between the two companies. Typically, the article kind of highlights the lawsuit. But when I do these intellectual property breakdowns and we really take a deep dive into the lawsuit, you can get a little bit more information as it relates to the company themselves, as well as kind of the back and forth and the banter, as well as get a little bit more insight into the actual IP owned by the plaintiff, in this case, the Olympic Committee. So this should be a good one, and hope you guys kind of take something from it. Please hit that like button, as well as that the subscribe button as you're coming into this thing. Again, it should be a good one. As we ended the last video, Prime Hydration, and I'll show this on my screen really quickly. Again, Prime Hydration, this is their IG page. This company is owned, or at least co-owned, by Logan Paul. And as you can see here, 2.2 million followers, so no slouch. And ultimately, again, they, at least for now, took down the actual Olympic branding or promotion of the actual Prime drink, the energy drink, the protein drink, whatever you want to call it. They took that down. So as you can see here, these are all older posts that they had, kind of going back to wrestling and kind of some other promotion with, Haney boxer and some basketball players, some wrestlers, again, so forth and so on. So they actually took down the Olympic version of the drink, and the Olympics just started here, so it's still new. From my understanding, the Olympics goes on for 16 weeks. So it'll be interesting on what, it's not 16 weeks, 16 days. So it'll be interesting on whether or not they actually kind of revamp the packaging and come back out with it to try to kind of capture some of that market in light of this lawsuit, or do they just say, hey, man, we're just going to scrap this plan altogether, stay in good graces with the Olympic Committee, stay in good graces with other people, so that if we want to do business with them down the line, that we can do it. So it's kind of, they're playing chess, maybe playing chess, not checkers, with this situation. So we're going to break down the lawsuit. I'm not going to hold you guys long for this one, but let me know in the comment section, do you think that they're going to at some point reintroduce a different version of the actual Prime drink, Olympic version, Olympic style of the drink? Or do you think they're going to, hey, we're just going to scrap it all together, as well as, just kind of do our thing with other stuff? So let me pull it up. I'm not going to keep you guys too long today. It's going to be a pretty quick one. I'm going to keep you guys. I know it's Sunday and Olympics is going and a lot of different things is going on, but I did want to kind of break down this one a little bit. So this is, I'm not sure what, I guess, action Prime Hydration has in Colorado, or what was the strategic reason for actually filing this lawsuit in Colorado. Typically, you will see New York, or you can actually sue somebody in whatever state that they're conducting business in. So I'm not sure why I would imagine that Prime Hydration is conducting business all over the country. So I'm not sure why they specifically did it for Colorado, but I'm pretty sure it was some type of strategic reason for this. So, as we look at it, the United States Olympic and Paralympic Committee, a federally chartered corporation, versus Prime Hydration. Surprised that they didn't put Logan Paul in there, but obviously he's the co-owner of Prime Hydration. Another thing that I'm interested, because as you will see here, this Olympic version of Prime Hydration was kind of built around or centered around Kevin Durant, who we all know is also on the men's Olympic basketball team, and they left him out the lawsuit. I think that was, a good reason for that, in terms of they didn't want to kind of rub Kevin Durant the wrong way, and probably just understanding that, man, he just probably was paid to do a job and kind of didn't really understand kind of the behind the scenes, the business aspect of it. So they probably left him out. Although typically you will sometimes see the promoter, especially if it's a big name, thrown into the lawsuit. So let's go through it here. The complaint plaintiff, the U.S. Olympic Committee, by and through the undersigned, attorneys as enforced complaint against Prime Hydration. So it seems like, okay, so they have the principal place of business. Interestingly enough, the Olympic Committee has their principal place of business in Colorado Springs. Colorado Springs is a good place. I've been there before. Seems like Prime Hydration has its principal place of business, even though it's organized under the laws of Delaware. The principal place of business is in Louisville, Kentucky. So again, it's kind of the nature of the action. Again, we're going to focus on the trademark infringement aspect, even though you have some unfair competition. Interestingly enough, it's a Ted Stevens Act, which is kind of passed by Congress centered around Olympics and amateur sports that they also threw in. Let's see here. Do I want to we'll skip jurisdiction. Let's get to the factual background. And I do want to bring up, I know one of the comments under the, I guess, shorter clip that I made surrounding this lawsuit a couple of days ago. Go check that out if you haven't. They kind of talked about how Prime Hydration was sold in the dollar stores. I'm not sure if they were doing that to make a mockery of it or to say, hey, man, y'all have seen it around. I know I was actually at a Sam's Club yesterday getting some groceries and things like that. I actually saw the Prime Hydration drink at Sam's Club. So, I mean, again, Logan Paul, they kind of have a footprint out there in some retail stores from all the way down to the dollar store up to Sam's Club, which we all know is a pretty big company that's known not only kind of countrywide, but worldwide with the Waltons or whatnot. So this drink is actually being sold. Now, obviously I didn't see the Olympic version sold. I just saw kind of their traditional packaging. I think it was red with the Prime logo. And another thing, the actual Prime logo, they're filing for trademark protection on that. Logan Paul and Prime Hydration is. It's still kind of going back and forth in the USPTO on whether or not they're going to allow that mark, but they are filing for trademark protection on that Prime logo. And again, just as an intellectual property attorney, anytime you got some IP, whether it's trademarks, copyrights, patents, you invented something, trade secrets, definitely make sure you're getting that protected because this stuff is extremely valuable. So let's go to the factual background. The Olympic Games are one of the most widely attended and viewed sporting events in the world. 206 countries will be represented in the 2024 Olympics in Paris, France. And man, you guys have to let me know what you think about the opening of the Olympics. I thought that was interesting to say the least, how they opened for the Olympics out in Paris. But yeah, that was an interesting one. But more than 10,000 of the top athletes in the world will travel to Paris to compete. It is expecting that 15 million tourists, that's crazy, will visit Paris during the games, and several billion with a B more individuals will be watching the games at home. The Olympic Committee is a federally chartered, internationally known corporation that serves as both the National Olympic Committee and the National Paralympic Committee for the U.S. As such, the Olympic Committee is responsible for training and funding the U.S. teams for Olympic, Paralympic, Youth Olympic, Pan American, and Pan American Games, while serving as a steward of the Olympic movement throughout the U.S. The Olympic Committee relies significantly upon the Olympic Committee relies significantly upon the licensing of its trademarks for its funding, the associated funding of the U.S. Olympic team. So I think this is interesting because what they're saying is, look, we have maybe companies like we are contracting with, whether it's NBC to kind of broadcast it. Again, that whole broadcasting is a copyright. You have, companies which they get off into the lawsuit, Coca-Cola, which they're kind of a partner of the Olympic Committee and are tasked with being able to kind of handle the branding of the Olympic trademarks and the Olympic Committee on drinks that Coca-Cola provides. And then you have, I would imagine, I'm not sure what the apparel company is, but I would imagine that they have an apparel company that they have licensed or given authority or authorization to actually sell clothing with the Olympic trademarks branding on it. And with all these companies from Coca-Cola to the apparel company to CBS or NBC, they're paying the Olympic Committee a royalty fee for kind of using their trademarks to earn money. So that's a good thing about this intellectual property. The Olympic Committee doesn't have to have a manufacturing facility or a TV broadcasting company, or they don't have to have a company that's manufacturing drinks. They have these trademarks that are valuable, and they can license those trademarks out, which is this paragraph that said, to other companies to actually provide the said thing, goods, clothing, drink products, actually the broadcasting of the events to the world in exchange for money. Hopefully you guys are picking up what I'm putting down, because that's extremely important when we're talking about intellectual properties. You don't have to be the one that's manufacturing this thing and bringing it to the market. you can actually license it out to somebody who's going to handle all the distribution and the production of the said thing and sell it. You can just collect a royalty. So that's essentially what the Olympic Committee is doing. And they take those funds and kind of pay for the travel and the stipends and all that of the actual athletes when they're in these games, such as in Paris, France. So that's essentially what that paragraph is saying. Let's go to 10 here. Pursuant to the Ted Stevens Olympic and Amateur Sports Act, Congress granted the Olympic Committee exclusive rights to commercially exploit certain marks and symbols related to the Olympic movement in the U.S., including the symbol of the International Olympic Committee consisting of the 5 interlocking rings, the word Olympic, and any trademark, trade name, sign, symbol, or insignia falsely representing, associated with, or authorization by the Olympic Committee and the Paralympic Committee, and so forth and so on. As set forth in the Olympic Charter, the Olympic Committee is obligated to protect the Olympic intellectual property in the U.S. for the benefit of the Olympic movement. In recognition and furtherance of the scope of the Olympic Committee's responsibilities and undertakings, Congress granted the Olympic Committee the exclusive right to use and control the use of the Olympic terminology and imagery within the U.S. That's essentially, what this Ted Stevens Act is breaking down. And they go more into the Ted Stevens Act in kind of paragraph 12 here, where they talk about the Ted Stevens Act authorizes the Olympic Committee to file a civil action against the unauthorized use of essentially anybody who's infringing a trademark. The Olympic Committee has authorization to go after them and file a civil lawsuit, which is in this case is trademark infringement. And that's important because typically, and I'm not sure why they had the Ted Stevens Act had to give them permission to do this. Typically, when you enter in some type of agreement with somebody, that agreement is going to reserve the right for the person who's authorized to sell it to bring a lawsuit to protect their investment. Just think about it. If somebody was infringing a trademark that you licensed, you got authority to use from, in this case, the Olympic Committee, and you couldn't sue them, and the Olympic Committee wasn't going to sue them. The U.S. wasn't going to sue them. Then you pretty much going to lose out on your investment. So typically, when you enter into these agreements, in this case, the Olympic Committee, they have control over these trademarks. They're licensing them out to the Coca-Colas and these different companies. If the Coca-Colas couldn't sue somebody, then an Olympic Committee wasn't going to sue somebody, then Coca-Cola would essentially lose out on their investment, because in this case, the owner of the trademark, which is the Olympic Committee, is bringing a trademark lawsuit against the alleged infringers, in this case, the Prime Hydration. But I would imagine that per the agreement between the Olympic Committee and Coca-Cola, for example, Coca-Cola also has the right to sue them so that they can protect their investment. But in this case, they didn't have to sue them because the Olympic Committee got on Prime Hydration's behind and filed a lawsuit in a civil action. As, again, what this article is saying, what the lawsuit is saying, that the Ted Stevens Act give the Olympic Committee the rights to do so. The intent of Congress in granting the Olympic Committee exclusivity over the Olympic brand, this is interesting. So they're pretty much saying, hey, Congress granted the Olympic Committee, us as the Olympic Committee, the exclusive right to be able to do whatever we need to do with it, whether it's license it, license the trademarks, protect the trademarks, file suit against somebody. We can do that. Now, the interesting thing is this is actually a U.S. case, and we all know that most times the Olympics is played in another portion of the world, in this case, Paris, France. So as a question for you guys as an audience member, and let me know your answer in the comment section, do you think the Olympics has the right to go after, for example, Prime Hydration? They weren't using this in the U.S., but they're selling this drink, say, in Paris. Do you think the Olympic Committee having a trademark here in the U.S. allows them to go after Prime Hydration in the U.S.? Not at all. You actually have to go in a court, in an area that is being infringed, where things are being infringed. In this case, if they wanted to go after Logan Paul and his company, Prime Hydration, because they were, or not, let's take out Logan Paul and Prime Hydration. Say another company who is associated in France is selling a drink with the term Olympics and Team USA, but they were kind of based out of Paris. They were selling it in Paris. Do you think that Olympic Committee can go after that company in the U.S.? No, they would actually have to, number one, just because they have a trademark in the U.S., that doesn't necessarily automatically give them rights abroad. They have to file for trademark protection, which I would imagine that the Olympic Committee has, file for trademark protection in the different countries that they want protection in, whether it's France, whether it's Germany, whether it's Italy, they have to file for trademark protection in those companies so that if somebody is infringing a trademark in that company, they then will have to sue somebody within that said company. They wouldn't be able to file a lawsuit against that company in the U.S. because it has nothing to do with the U.S. and U.S. trademark law at that point. You have to file, if the company was a French company and they were based out of France and sell it in France, you wouldn't be able to sue that company in the U.S. You actually have to get trademark protection in that country first and then be able to sue them in that country. And this is important because typically a lot of the times when we look at these lawsuits, we're looking at just the kind of U.S. component of it. However, there is an international component where you will have to have protection of your trademark internationally to be able to go after a company for trademark infringement internationally as well. So don't lose sight of that. I thought that was interesting, or it was a good kind of bringing that up, especially as we're kind of going through this. Let's hear 14. As the U.S. Supreme Court has explained, the clear intent of Congress in granting the Olympic Committee exclusivity over the Olympic brand is to generate revenue to finance the U.S. involvement in the Olympic Games. So we kind of skip that. The Olympic Committee raises money it needs to operate by in large part license the use of its IP to sponsors and licensees. These legitimate license fees pay for house, feed, train, and otherwise support the Olympic athletes and finance this country's participation in the Olympic Games. I would imagine that they make millions, maybe tens of millions of dollars from licensing their trademarks. So these are the trademarks. And hey, if you've been following my channel for any amount of time, you would know that you have to get, it's no kind of one size fits all trademark. You have to get trademark protection in every category, let's call it category or class that you're looking to do business in. So if you're looking to sell or use your trademark for sports drinks, you have to get it in a sports drink class. You have to get it protected in a sports drink class. If you're looking to have your trademark get protected in clothing and apparel, you have to get it in a clothing and apparel class. If you actually go to the test database, United States Patent and Trademark Database, with all the data, where you can see all the actual protected trademarks or pending trademarks or abandoned trademarks for that matter, you will notice that it's a ton of companies that own the same mark. And that's because one company may have it in clothing, another company may have it in entertainment, another company may have it in electronics. You can protect the same name as long as, or two dissimilar companies, different companies can protect the same name as long as it's not in a related class or category. But to the extent that you're trying to protect it in the same category as another company who's already protected in there, you wouldn't be able to allow to do that. So I'm bringing that up because it's going to be important to pay attention to that as we're looking at the lawsuit. And you can tell they have the term Olympic and ornamental pins protected in the ornamental pins category, which is 14, the clothing category, which is 25, the label pins, which is again 8 and 14, printed publications, pamphlets, which is kind of international class 9, 16, and 28. Then you have the term Olympic spirit that's protected in metal license plates, class 6, and then again going for gold, which they have protected in class 41, which is education and entertainment services, as well as class 35, which is promoting the public awareness of the Olympic movement and its ideals. Then you got Team USA, that is a registered term that's protected in a number of categories such as posters, bumper stickers, and window cleans, which is 16. And they have it protected in promoting and public awareness of the Olympic movement, class 35. Fundraising activities, class 36. Decorative movements, class 9. You have backpacks, duffel bags, luggage tags, things like that, which is class 18, beer mugs, so forth and so on. So you can see that they have the term Team USA as a protected term, but they have it protected in multiple classes, which is okay. And it's actually, you need to do it for every class that you're looking to operate, essentially, or use the mark in. So that's what I like to tell people. Like, for example, you see the term, it comes up a lot in the restaurant category, where you may be calling your restaurant a name, which you need to protect it in that restaurant services, but then you may actually call a burger or one of the sandwich that you're selling it in your restaurant the same name as the restaurant, maybe the featured sandwich. So you need to also protect that name in the sandwich category. Just because you protect the name in a restaurant category, that doesn't necessarily give you protection of the name in the sandwich category. So you actually need to be able to protect it in both the restaurant category as well as the sandwich category. That's essentially what the Olympic Committee is doing here, where they have Team USA and they're protecting it in a number of different categories, which again, they need to do. Let's go down to 17 here. The Olympic Committee has used the famous Olympic trademark in interstate commerce since 18. Man, they've been using this for over almost 130 years. Well, almost 140 years. That's crazy. As a result of its long-standing and extensive use, the Olympic mark exclusive right to be granted by this act on significant trademark rights in the market link. So they're talking about essentially the term Olympic being a special mark. Let's go down to 19 here. So they're talking about the Olympic Committee has an agreement with Coca-Cola that allows it exclusively. Because again, a lot of times what you can have here, you can have non-exclusive use or exclusive use. So in one instance, you can say, okay, I'm gonna allow y'all to use this trademark for beverage, but I'm gonna allow this other company to use it for beverage as well. But other times you can say, hey, I'm gonna grant this company an exclusive use to use this beverage, meaning that I can't allow any other company, at least any other company within that industry, in this case, the beverage industry, to use that trademark. And it seems like that's what the Olympic Committee gave to Coca-Cola, at least to Coca-Cola. Coca-Cola made a significant monetary contribution for such rights. I would imagine that they had to pay them millions of dollars to do so, to be able to use that term Olympic exclusively, which for beverages in the U.S. as well as abroad. But again, to the extent that somebody is infringing their trademark abroad, the Olympic Committee can't sue that company here in the U.S., that international company in the U.S. They would actually have to kind of file suit internationally in that company that in this case, the beverage is being infringed on. Much of the value of the sponsorship agreement is derived from its exclusivity. So it seems like based on Coca-Cola having exclusive rights to it, they actually pay a premium to be able to use the trademark terms. So it says exclusivity of this agreement, which is vital to funding of the training, entertainment of. So essentially, the exclusivity and the funds that are given to that is used to fund the Olympic Games, or the athletes who are taking place in the Olympic Games. As we all know, the games took place on Friday a couple days ago and are going to last 18 days until August 11th. Then now they're talking about, okay, the defendant, Prime Hydration, had willful attempt to trade on the IP of the Olympic Committee based on the product packaging, internet advertising, and promotions featuring Prime Hydration, flavor, and athlete Kevin Durant. So these are some of which, again, we talked about in our short breakdown of this, some packaging, which again, you see it was almost kind of centered around Kevin Durant. Now, the fact that they're using Kevin Durant, the fact that they're using Prime, the fact that they're using the colors red, white, and blue, that's not an issue. What the Olympic Committee is saying is an issue is the fact that they're saying Olympic, the fact that they're saying going for gold, the fact that they're saying Olympian, which as we showed above, they're saying that they have rights to the term Olympic and the term going for gold. I'm not sure why they didn't put Olympian in here, the trademark that they have on Olympian. But essentially, they're saying, hey, on their packaging, they're using our trademark terms, Olympic, Olympian, and going for gold, which is infringement of our trademark. Now, as I talked about before, I thought they had some good arguments, Prime Hydration did, because it doesn't look like, maybe outside of, which I'll show here, the Team USA. Now, the Team USA, they do have it, not necessarily for energy drinks, sports drinks, but they do have it for, at least for, let's see here, class 21, I think. They do have it for like more mugs, drinking glasses, water bottles. So they do have Team USA kind of protected in the class that's at least around water bottles, even though it's not for sports drinks, energy drinks, things like that. But as they at least laid out here in a complaint, the Olympic Committee did, the term Olympic and the term going for gold is not protected in sports drinks, energy drinks, the actual way that Prime Hydration is using the term. So in other words, Prime Hydration is using the term Olympic and Olympian and going for gold in the sports drink, energy drink class. And at least doesn't it look like, at least according to the table of the protected terms of the Olympic Committee, they have that term, those terms protected for sports drinks, energy drinks, or in other words, the way in which Logan Paul and his company Prime Hydration is using a mark for. So in my opinion, as an attorney, if I'm trying to fight for the other side, I'm gonna say, look, y'all, you guys don't even have the term protected in these classes in which we're using it. Just because you guys have it protected in license plates and promotional materials and things like that, I don't think that you guys are using it or have it protected for the class in a way that we're using it, which is sports drinks, energy drinks, and therefore we're not committing trademark infringement. I think that is an argument that Prime Hydration, Logan Paul Company can actually put forth. I'm not sure if they put forth that that argument. Obviously, we know that they took the actual drink down, but I would definitely put forth that argument if I was an attorney representing Logan Paul and Prime Hydration. So let's get down here again. This is another like a social media post. They're promoting it. Kevin Durant Prime. Again, some other social media posts. This is what we just took a look at here. which again, you can see that they have taken it down, at least based on what we looked at and what they had put in a what's the name in a post. But it seems like at least on, earlier they had Kevin Durant, as well as I think this guy name is Kai, as well as Logan Paul, promoting that drink. See on the website here, we didn't bring up the Prime Hydration website, but you see on the website that they were also promoting that hydration Kevin Durant Prime drink, which they're no longer doing. By the way, this is again, based on seeing like taking pre-orders. This on Twitter, I think. It looks like they took all this stuff down. So yeah, see, this is where you have the Team USA. I think they kind of said, no, not here. Let's see here. Okay, this could have got him in trouble. This whole Team USA Kevin Durant. So that could got him in trouble. That could have got him in trouble. Again, just some more kind of promotion of this stuff. I do want to kind of put forth that they actually could have got over this lawsuit pretty easy just by taking the term Olympian, going for gold, and Team USA off the actual packaging of the sports drink. So again, they can't stop them from using the colors red, white, and blue with the sports drink, nor the term Kevin Durant, because they don't own the trademark for Kevin Durant. Then Prime, as we all know, is their intellectual property that they're looking to protect. So an easy way for them, Prime Hydration, to get over this lawsuit is just to update the packaging or remove Olympic, going for gold, and they would have been able to sell it, which I'm not sure why they didn't do that. Maybe that's what they're going to do, and that's why they took it down, and they have a couple weeks to try to kind of revamp things and come out with it. It'll be interesting. I think that they will do that just because they can really kind of take advantage of this. But again, they may say, man, it's not worth it. Let's save the relationship with the Olympic Committee, and we're not going to do it. But let's go here. Defendant use of the goodwill associated with the intellectual property of the Olympic Committee to sell and promote his brand is okay. Essentially, they're saying that Prime Hydration used the goodwill to promote the brand. This solicitation is evidenced by defendant's blatant use of the intellectual property on the product. On July 10th, it seems like counsel of the Olympic Committee contacted Prime Hydration and maybe sent them a cease and desist letter to request they cease infringement. The defendant, however, Prime Hydration, did not discontinue all use of the intellectual property of the Olympic Committee. And it seems like they're saying that the defendant, Prime Hydration, is going to continue to ship the product after receiving the letter. So it seems like, again, they sent the letter July 10th telling them to cease and desist, and they are keeping it. And obviously, they took it down at some point. That's crazy how they a lot of times kind of take the product down, or the alleged infringing product down after the lawsuit is filed. So a lot of times you will send a cease and desist letter, which you kind of have to do. But a lot of times the defendant will blow off that cease and desist letter. When you actually filed that lawsuit, that's when they're like, hold on, let's take this down. Let's go back to the drawing board and let's figure this thing out. So it seems like that, at least with the Prime Hydration did in this case. And again, they're talking about consumers encountering Prime Hydration use of infringing marks in connection with the goods and services are likely to mistakenly assume a connection with the essentially cause confusion, which is the whole standard of trademark law. So we're not going to get off into the Ted Stevens Act. That seems like something passed by Congress that they're saying that Prime Hydration is infringing or is in violation of. But this is, the violation of the Lanham Act, essentially Section 114, which is the trademark infringement. Plaintiff, the Olympic Committee may bring a civil action against any person without consent of the registrant uses a registered mark in connection with the sales and goods or services when it's likely to cause confusion, which again is the whole point of trademark law, likely to cause confusion. Based on the foregoing, Prime Hydration is liable for trademark infringement of the terms Olympic, Team USA, going for gold. So those three trademarks that they're saying they're committing trademark infringement on, which I think, like I said, the quickest way for Prime Hydration to get over this is just take those terms out of, which I thought they were a small component of the mark anyway. So if you don't want to make the arguments that I put forth, at least kind of take those terms out of it, and then you're good to go. Prime Hydration has and will continue to receive revenues and profits resulting of its infringement. So they're pretty much saying, hey, based on this infringement, they're going to continue to make money off this stuff. And so we essentially want not only for them to stop it, but we want to get our money back. And then you see some other unfair competition, trademark dilution, stuff that's typically added to the complaint. Got some, basically being in Colorado, is a Colorado Consumers Protection Act that they also are in violation of. And then you see the trademark infringement and unconfidential. So typically, trademark is one of those laws where you have a federal component, which you typically file in a federal law, but they also have a state component. But typically the states are not set up to be able to analyze and kind of go through this whole trademark infringement analysis as the federal courts are. So you typically are kind of going to file it in federal court, and more times than not, that state court is going to really adopt the ruling of the federal court because they don't kind of really have the tools and the resources to be able to kind of go through this whole, trademark analysis, if you will, trademark infringement analysis. So that's pretty much it. You guys have to let me know what you guys think. Like I said, I know this is going to be a short one. It's 30 minutes into it. You guys have to let me know what you guys think about it. Do you think that Prime Hydration, Logan Paul, they're going to kind of rebrand and come out with something? Or do you think they're just going to say, man, this is not worth our time? Let's kind of, a lot of times you can want to save face and save that relationship with a company, especially if you think you're going to work with them in the future. And as a result of that, you can say, man, let's stay in good graces. Let's stay on their good side and kind of go from there. So maybe they're taking that approach. You guys have to let me know what you think is going to happen. Hopefully you guys got something out of this video. Again, I wanted to kind of break down the lawsuit to give a little bit more insight into kind of what's going on, the Olympic Committee and kind of what they have. It seems like Congress has given this Olympic Committee a lot of power as it relates to the intellectual property of the actual U.S., which is important because, as we all know, Uncle Sam in the U.S., they kind of fund a lot of different departments, the courts. They fund Social Security, a lot of departments. However, this Olympic Committee department is not a company that they fund, and they probably did that because they're like, look, you actually have valuable assets that you can make money off of so that you don't have to be in our product. I think I was saying this in my short clip, kind of talking about this, where the USPTO, which again is a branch of the federal government, is one of the only branches that makes money. A lot of the federal government loses money, and when they take our taxes, they kind of pay for those departments. But the USPTO, United States Patent and Trademark Office, is one of the only departments of the federal government that actually makes money, and is in a positive, in a black, as opposed to being in a red. So I would imagine that Congress is like, hey man, y'all don't need to be in our pockets because y'all gonna make money because y'all have this valuable asset. That's crazy to think that that's how valuable intellectual property is, that the United States government is saying we're not going to fund this Olympic Committee because y'all have such a valuable asset that you guys can make money on your own, where we have to fund all these other agencies because they're not going to make money. The courts don't make money. The Social Security office doesn't make money. Different offices, that government office that they give money, those don't make money. However, the Olympic Committee, Congress is saying y'all gonna make enough money because y'all got this valuable stuff, intellectual property, not stuff, but intellectual property that y'all can license out and make money on. That's Congress showing you the power of intellectual property. And so again, hopefully you guys kind of take this, process it as you guys create and think of your intellectual property. Make sure you protect it, whether it's a copyright, whether it's a trademark, whether it's a patent. Make sure you're protecting this stuff. You're monetizing off of this stuff because it is very valuable, and you're doing it the right way. Hopefully you guys got something out of this. I'll see you next week. Take care. Peace.